Good day, Crime Talk aficionados. It's Sunday, but guess what we have for you? That's right. The weekly recap of all the top stories for the week of October 13th, 2025, conveniently located all in one location. That's right here. I hope you enjoy it. Thanks for watching. And remember, the Constitution matters.
All right, lawyer.
Let me also remind you, listen, these things are flying off the shelf. People were literally sending, I don't know how many of these out a day, but it's a lot. So get them while they last. You need to do it. Everyone's getting them for their, keychains, putting them on their bags to identify their luggage. You name it, people are doing it. It's $5, ladies and gentlemen. Best way to support the channel, $5. Can't do it. And also, let's not forget, these are also hot sellers as well. Lawyer. And this one is a big seller too. Ben told you we were doing a little more merch and didn't realize what an amazing response that we would get. Just literally seems like they're flying off the shelf. So go check out the link below. And the first matter on the docket is Luigi Mangione. That's right. His attorneys say it was all illegal. So the attorneys representing Luigi Mangione, the 27-year-old accused in the fatal shooting of the United Healthcare CEO Brian Thompson, have filed a motion with the federal judge there in Manhattan to dismiss several charges from his indictment, including the sole count that could result in the death penalty. Now, the motion filed on Saturday also requests the exclusion of Mangione's statements to police and evidence recovered from his backpack, citing alleged violations of his constitutional right. Come on, quick quiz. What constitutional right presents unreasonable searches and seizures? That's right, the Fourth Amendment. The defense argues that the law enforcement failed to inform Mangione of his Miranda rights prior to interrogation following his arrest. Additionally, they contend that officers conducted a warrantless search of his backpack, which contained a firearm and ammunition linked to the crime that he is accused of committing. Now, these procedural lapses, according to the motion, render the evidence completely inadmissible in the court of law. Now, as you may recall, Mangione has entered a plea of not guilty to both state and federal charges stemming from the December 4th, 2024 shooting in which Thompson was gunned down upon arriving at a Manhattan hotel for an annual investors conference. Now, the shooting triggered a widespread manhunt across multiple states. The suspect at the time, Luigi Mangione, allegedly evaded immediate capture by fleeing the scene on foot, cycling to Central Park, and then taking a taxi to a bus terminal serving several routes. Police ultimately apprehended Mangione 5 days later in Altoona, Pennsylvania, approximately 233 miles from New York, based on a tip from a McDonald's employee. Now, the defense submission includes a detailed timeline of the arrest, supported by body cam worn footage depicting Mangione seated alone at a table wearing a white mask. Officers initially approached him, citing reports of suspicious behavior and activities after he had been present for about 40 minutes there in the McDonald's. When asked for his identification, Mangione provided a New Jersey driver's license bearing another individual's name. As Mangione began eating, officers instructed him to stand with his hands on his head and to have a pat down. One officer then called for reinforcements, expressing certainty that Mangione matched the suspect's description. Additional personnel arrived shortly thereafter, leading to his detention. Now, Mangione has remained in custody without bail since his arrest, and this most recent motion follows an earlier request by Mangione's legal team to dismiss the federal charges entirely and eliminate the death penalty option, prompted by statements from the United States Attorney General Pam Bondi. And in April of this year, Bondi instructed the New York prosecutors to pursue the capital punishment, describing the act as premeditated, cold-blooded assassination that shook America. That's the Attorney General telling his people, her people, how to go forward. I don't think that's going to get dismissed on those grounds either. Anyway, while the murder prosecution typically occurs in state court, federal authorities have charged Mangione under a statute addressing homicides involving firearms during crimes of violence, and represents the only charge eligible for the death penalty, as New York State does not impose capital punishment. Now, the defense challenges this count, asserting that the prosecutors have not adequately specified qualifying underlying offenses and that the alleged stalking does not constitute a crime of violence under the law. The case has drawn, obviously, significant public attention, fueling widespread criticism of the U.S. healthcare sector and heightened security concerns among the corporate leaders. Now, investigators discovered ammunition at the crime scene inscribed with the words delay, deny, and depose, a phrase echoing critiques of insurance practices that delay or deny claims, potentially leading to the removal of executives. Now, a ruling on the motion is pending, obviously, and the trial's outcome could influence how federal and state jurisdictions are going to intersect in this particular case. Obviously, the prosecution to file a response in federal court, state court, they usually are wishy-washy about it and say, let's just have a hearing. Now, let's get into the bones of this, so to speak. All right, let's get into the weeds of this particular motion. All right. The defense has filed a motion saying that there was no reasonable suspicion, no probable cause, illegal arrest, failure to advise and Miranda advisements, et cetera, et cetera, et cetera. Okay. There you go. At that point, the burden now shifts to the prosecution to prove by clear and convincing evidence that all the evidence was obtained legally. Well, what's the first basis? There's no reasonable suspicion to approach Luigi Mangione, right? Well, the police officer receives a tip saying, hey, there's a guy that fits the description of Luigi Mangione, the guy wanted for murder. Reasonable suspicion. Cop looks at it. Okay, fine. The police officers then request identification to see who this guy is. Oh, turns out it's a fake ID. They run his ID. Oop, not him, right? They then confirm it's Luigi Mangione. They become quite positive. They ask to frisk him down, right? You can do that for officer safety reasons. That's what they're going to say. They confirm it's Mangione. They arrest him. They then take his bag, open it up, look into it. Once again, they're going to say officer safety reasons why this person is known to be armed and dangerous. They're also going to say, well, we couldn't, just take his bag and not inventory search it because as the police have a duty to protect the property, they don't want to be accused of, doing something. So what do? They open they open the bag. Oop, they find a firearm. Boom, there you go. The question is, could they go into the bag? The police, the prosecutors will argue that everything was completely legal. There was reasonable suspicion. There was probable cause to arrest once they determined that this was, in fact, Luigi Mangione. They're going to argue that it was an inventory search or inevitable discovery, and therefore the motion to suppress should be denied. Now, obviously, this was supposed to take place in the Pennsylvania case, but Luigi Mangione insisted that he be brought to court, so the matter gets delayed because the feds don't want to send him over to Pennsylvania for the hearing since Mr. Mangione doesn't want to appear via WebEx. So now the federal judge is going to decide what this issue is. Now, in theory, I guess the feds could say motion to suppress denied, and the state could say motion to suppress granted, but pretty unlikely. All right, unless one of the judges just think the other side got it totally wrong. We're a wait and see, okay? Normally, if the prosecution thought that there was an issue with the search and seizure of the evidence in this particular case, they wouldn't be moving forward with the death penalty. Obviously, we'll have to wait and see, but at first blush, it appears as though, based on what we know, that, probably the motion to suppress will be denied. We'll see if I'm right. We'll see if I'm wrong. Next on the docket, Corey Richins filed some paperwork in her murder case. What is it? So in the legal filing seeking access to financial records associated with her deceased husband's trust, Corey Richins has alleged that her sister-in-law disbursed funds to individuals involved in her ongoing criminal proceedings. Now, Corey Richins, who is a resident of Utah and mother of 3 children, she also authored a children's book addressing themes of loss following the death of her husband, which coincidentally she's accused of killing. Anyway, she now faces charges of administering a lethal quantity of fentanyl, Eric Richins, via a cocktail back in 2022. Now, police contend that the act was premeditated to secure benefits from his life insurance policies as well as his trust holdings. Now, the recent motion submitted by Richins' legal team asserted that Casey Richins Benson, Eric's sister and administrator of Eric Richins' living trust, has not fully adhered to a subpoena for the trust's financial documentation. Now, although Katie's counsel supplied partial records, significant portions were retained on the grounds that the Richins lack entitlement to those documents. And Richins' attorneys are requesting a comprehensive detail of the trust's operations, encompassing inflows, revenues, and disbursements to any parties. Of particular interest are reproductions of checks issued from personal or business accounts to persons linked to the inquiry or legal actions against Corey Darden Richins. In the objection filed with the court, the documents state that Katie's legal representatives acknowledged disbursements to two individuals, Brooke Carrington and Matthew Throckmorton, describing them as past and present expert consultants. The response further maintained that the communications with these parties are protected under privilege. Now, Richins' trial on murder charges is set to commence in February of 2026. You know, when you start subpoenaing records, you can do that. And it sounds like legal counsel said you need to turn over certain documents, but other stuff is, in fact, privileged. It doesn't mean it won't be turned over. There'll have to be an argument about it with the court. There'll be a privilege log saying we have these documents, but they're privileged. And then the judge will decide whether they need to be produced or not. Payments to experts, kind of weird that the trust would be paying for experts in the criminal case. Very unusual. But they also could have been retained for consultation as it relates to a civil case as well, which may also be the issue at hand, but we just don't know yet. So once again, I hate to say it, but we're going to have to wait and see. So make sure you check back and we'll have the answer for you. Brian Kohberger again. So in what could possibly be a significant development in the case of Brian Kohberger, the now convicted murderer of 4 University of Idaho students, we have discovered through some unsealed court documents, kind of some prosecution witness list individuals and, you know, the timing as it related to the plea deal. Now, I'm not a big believer in coincidences, but you never know if this was the smoking gun or the one witness that said to Brian Kohberger, I'm going to plead guilty. So these documents indicate that Kohberger's sister, Amanda Kohberger, was among potential witnesses for the state during the guilt phase of the trial. Notably, Kohberger entered into a plea agreement days after the witness list was filed, raising questions about the potential influence of this revelation on his decision. Kohberger, who faced charges for the 2022 stabbing deaths of those 4 University of College students, avoided a full trial by pleading guilty to 4 counts of murder plus the burglary count. Now, this agreement spared him from the possibility of capital punishment, resulting in 4 consecutive life sentences without the possibility of parole as imposed during his sentencing back on July 23rd of this year. Now, the timing of the plea, shortly following the June 25th motion to unseal the witness list, has drawn attention to the inclusion of Amanda Kohberger as the sole immediate family member listed by prosecutors. Now, the record suggests that Amanda's potential testimony may have stemmed from a prior incident in 2014 when Kohberger was charged with misdemeanor theft for allegedly taking his sister's cell phone. This event was reported by their father, Michael Kohberger, according to the documentation. Now, the prosecution, led by the Latah County prosecutor Bill Thompson, had previously indicated that Kohberger's family members were unlikely to provide testimony beneficial to his defense. However, Amanda's unique position as a witness for both sides is evident. She also appeared on the defense list of mitigation witnesses intended to offer evidence that could potentially lessen Kohberger's perceived culpability if he was ultimately convicted. Now, the unsealed list, ordered released by Ada County Judge Stephen Hippler, encompasses over 180 potential prosecution witnesses for the guilt phase and 56 for the defense mitigation phase. Among the prosecution's notable inclusion were surviving roommates Bethany Funk and Dylan Mortensen, obviously, as well as Ethan Chapin's triplet siblings, Hunter and Maisie Chapin, who were present at the crime scene on the morning the bodies were discovered. Now, in response to the plea deal, Stacy Chapin, mother of Ethan and the triplets, expressed relief that her children and the surviving roommates would not need to testify, thereby avoiding the re-traumatization of recounting the events. Now, the defense's mitigation witness list featured additional family members, including Kohberger's other sister, Melissa, and his parents, Michael and Marianne. It's also included John Snyder, a professor at Washington State University, where Kohberger served as a teaching assistant. Now, Snyder's inclusion is noteworthy given prior professional tensions. Kohberger had received a conduct warning following a verbal altercation with Snyder, and he was subsequently informed that his teaching position would not be renewed. Following Kohberger's arrest, the university issued a directive prohibiting him from remaining on the campus premises at all. Now, the court's amended order on unsealing, redacting, or maintaining sealed status of the records addressed concerns from both parties regarding witness privacy and the potential for harassment. While acknowledging past instances of media scrutiny and threats to some witnesses, the order concluded that the public's right to access outweighed these risks, particularly as no severe threats to life or safety had been reported, and specific redactions were applied to protect personal addresses and locations, but the witnesses' names themselves were disclosed. Now, this case, marked by intense public and media scrutiny, underscores the complexity, obviously, of high-profile criminal proceedings, including the delicate balance between transparency and witness protection. Kohberger's decision to accept the plea deal, aligning closely with the revelations of his sister's involvement, certainly highlights potential family dynamics at play, though no direct causation has been established. Now, as the matter concludes with Kohberger's incarceration, it serves as a reminder of the profound impact on all parties involved in such tragedies. Good for the judge releasing it. It is what it is. People's names, it's a public information. Trials are meant to be public. I've said this before. I will say it again. I disagree with some of the judge's decisions, particularly not Judge Hippler, but the other judge that ruled on the crime scene photographs. Hey, you don't want to look at them. You don't have to see them. But hey, the judge has ruled. It is what it is. And guess what? Yeah, Brian Kohberger faces some challenges in prison. I guess that's the case. So Steve Gonsalves, father of Kaylee Gonsalves, one of the 4 University of Idaho students killed, has shared some insights regarding the reported difficulties faced by Brian Kohberger in the Idaho Maximum Security Prison. Now, the victims of the 2022 tragedy include Kaylee Gonsalves, Madison Mogan, Ethan Chapin, and Zena Kernodle. And in an interview on the Banfield show alongside his daughter, Stephen Gonsalves discussed recent developments in the case, and he remarked, hey, there's reports indicating that old Kohberger is struggling within the prison environment, particularly in his assigned block. He appears to be vocal about his rights, asserting that they must be upheld. And Stephen added that individuals who commit such crime must face the consequences, and his complaints within the facility are reportedly not improving his situation. Now, the family also expressed frustration over reports that Lifetime is producing a film about the murders titled Ripped from the Headlines. According to Deadline actor Miles Mary has been cast to portray Kohberger. The daughter voiced her dismay, stating, "It's deeply upsetting. My sisters are not merely a headline or material for a Lifetime movie, and the scripted portrayal of their lives is profoundly frustrating." Now, the family was neither consulted nor informed prior to the public announcement of the film. And Stephen Gonsalves expressed his shock, saying, "It is disheartening that someone feels entitled to tell the story of your child and their closest friend, people you interacted with daily, without your input. It feels as though someone is intruding into your life and exploiting it for display." Couple of things. All right. First, Brian Kohberger. You know what Brian Kohberger should do? He should have his mother call prison. Let me give you a quick example. Had a guy, did some bad things, went to prison. Apparently he's not bonding well with other people. Family calls and says, what can you do? He's in danger. You need to get him out of there. And I'm literally like, there's nothing I can do, right? Mom's like, well, should I call down there? No, that will make it absolutely worse. Okay. He's in prison. This is not, he is in grade school and little Johnny is bullying him and you need to let somebody know. This is prison. You're a big boy. The only remedy is to go check yourself into protective custody. All right. Can't have your mommy call the Department of Corrections. Then even the staff will be on you, and wait until the fellow inmates find out about it like that. You will be the biggest target ever. All right. And I do think it's always funny that, the people that break the crime the most, ones that go to the Department of Corrections, are always the ones that demand that their rights are absolutely followed at every juncture. Like Brian Kohberger saying that he has rights and he expects his meal. Yes, it's always ironic, isn't it? Now, in the whole issue of Stephen Gonzalez and the family not being consulted, there's so much public information out there. I hate to say it, but they don't need to consult the family. And if I really was going to get cynical, it sounds like maybe they want to be a part of it and, maybe get a little cash out of the whole thing as well. I don't know. I get their frustration, but it's all public information and knowledge. Certainly it'd be nice to have the family's input, you would think. But if they're not going to be pleased with the project unless they get paid for it, then Lifetime should go ahead with their movie, in my humble opinion. Luigi Mangione. Don't you all worry about Luigi Mangione, okay? Luigi, he's the beacon of modern heroism and apparently is swimming in about $40,000 worth of prison pocket change, courtesy of his adoring fan club, all while he lounges in jail pondering his federal murder rap for offing United Healthcare bigwig Brian Thompson. Now, this 27-year-old alleged sharpshooter who supposedly shot Thompson right in the middle of New York streets during some fancy conference back in December of 2024 has somehow morphed into a celebrity heartthrob after a dramatic 5-day game of hide and seek with the police. Now, according to the ever-reliable gossip mills, his devoted followers are stuffing his commissary account at the Metropolitan Detention Center like it's a GoFundMe for the world's most misunderstood vigilante, ensuring his incarceration is as plush as his budget spa retreat. Now, little birdie from inside the slammer whispers that our boy can blow up to $160 daily on gourmet delights. Think a luxurious jar of Nutella for a steal at $4.90 or some gourmet sausage, $2.90. Why not splurge on oatmeal for $3.65 or some zesty jalapeno wheels at $3.20? And let's not forget the pinnacle of fine dining, a slab of Velveeta cheese for $3.70. Who needs freedom when you've got processed cheese? Drawing from ancient prison shopping catalogs in New York's inmates like him can snag essential like vitamins, deodorant, laundry soap, and booze, free beverages without breaking the bank, because nothing says rehabilitation like affordable hygiene. But wait, the generosity doesn't stop at cash. His fan mail is piling up like junk in a hoarder's attic. Reports suggest that these little letters from enamored ladies turn downright steamy, with one gem allegedly expressing a desire to freak out on his manhood. How poetic. Sources claim he's raking in up to 200 such love notes daily, because nothing screams romance like corresponding with a guy accused of cold-blooded murder execution. Even the former president couldn't resist chiming in on this cultural phenomenon, opining to a news outlet that the ladies fawning over him represents some kind of social malady worth a deep dive. It's not possible, he declared, as if the world hasn't seen weirder obsessions. Mangione, the ever picture of innocence, has entered a not guilty plea and even scored a minor courtroom victory when those pesky state terrorism charges got tossed out for lack of sufficient evidence on that terrorism angle that they were going for. His cheer squad hails him as the ultimate corruption slayer, claiming he chomped a piece out of the rotten system by allegedly dispatching the 50-year-old executive. Now, the Ivy League whiz kid has apparently ascended to icon status in the healthcare rebellion, with supporters painting him as a crusader. He reportedly etched deny, depose, and delay on his ammo, a subtle nod to his beef with the medical machine, fueled by his own chronic back woes. Last month, his legal eagles pushed to ditch the federal charges and nix the death penalty option, blaming loose lips from the U.S. Attorney General's office for tainting the jury pool. Back in April, she urged prosecutors to go for the ultimate punishment, dubbing the hit as calculated. Ruthless slaying rattled the nation. While most killings stay in a state court, they've slapped him with a federal gun-related murder count tied to violent crimes, which conveniently opens the door to the capital punishment, since the New York doesn't bother with that anymore. Ladies and gentlemen, like I said, don't worry. Luigi's going to be just fine. Whatever happens, he's going to have his fan club. He's living large. You got 40 grand in your bank account at the commissary. You are billionaire status in there. You get protection. You get whatever you need when you have the keys or the cash for the commissary. Can't make this stuff up, ladies and gentlemen. Next on the docket, the dad admits his role in the death of baby Emmanuel Haro. So in a chilling development in the case of missing infant Emmanuel Haro, Jake Haro, the dad, who's 32, entered a plea of guilty to charges including murder, filing a false police report, and child endangerment. Now, this admission came during a court hearing on October 16th in Riverside, California, where Jake appeared visibly distraught, shedding tears as he acknowledged his role in the death of his child. Now, you all may recall this case began on August 14th of this year, when Emmanuel, a 7-month-old boy, was reported missing from a sporting goods parking lot in California. His mother, Rebecca Haro, initially claimed she had been assaulted, rendering her unconscious, and that upon regaining awareness, she discovered her son had been abducted. Police, however, soon uncovered some, inconsistencies in her story, leading them to conclude that no such kidnapping actually occurred. Investigators revealed that the couple had ceased cooperating with law enforcement shortly after report, prompting a shift in the probe's focus. By August 22nd, both Jake and Rebecca were arrested on suspicion of murder. Officials now believe Emmanuel perished days prior to the fabricated report, with the last confirmed sighting of the child on August 5th of this year. Despite exhaustive searches, including one in which Jake briefly assisted police near a freeway after his arrest, the infant's remains have yet to be recovered. Now, the Riverside County District Attorney, Mike Hestron, emphasized that evidence points to prolonged abuse as a contributing factor in the child's death. Jake's guilty plea was made without any agreement in place, leaving his sentence potentially ranging from 25 years to life in prison to the discretion of the judge. Sentencing is now set for November 3rd, 2025. Rebecca, meanwhile, has pled not guilty to identical charges of murder and filing a false report. She remains in custody with bail set at $1 million and is scheduled for a preliminary hearing on the same date as Jake's sentencing. Now, Jake, you got to admire the guy, to be quite honest with you. He acknowledged he did it. He's probably still going to get life. At least he stepped up and was a man as to what he did. Obviously, he had a right to go to trial, make the government prove their case beyond a reasonable doubt. And he's like, nope, let's do it. Unprotected, no plea agreement whatsoever. He'll maybe get a few years off from the judge, but it's probably still going to be a life sentence one way or the other. Well, anyway, compounding the horror, records show that Jake's prior involvement in child abuse back in 2018, he was convicted of willfully neglecting and severely injuring his then 10-week-old daughter from a previous relationship, resulting in permanent disability, including cerebral palsy and immobility. He received probation and work release at that time. The couple also shares a 2-year-old child who has been removed from their care by Child Protective Services. Obviously, devastating case, severe consequences. We got domestic deception and abuse, leaving the community grappling what the heck is going on. as it relates to Emmanuel's fate. Obviously, as the proceedings continue, more details will emerge to this heartbreaking case. I just don't get it, man. Don't hurt kids. Pick on somebody your own size. Little kids, really? That's just not cool. And old Jake, he may have a real problem. He may have a real problem when he gets to prison. We've talked about this before. There's a certain hierarchy in the prison system. Obviously, some crimes give you status, for example, like murder, but they really don't like crimes against children, obviously of the sexual nature and obviously of the child abuse nature either. Why? Because unfortunately, so many people in custody have experienced those types of abuses. Well, and guess what? Now they've got a lot of people in there with the same thing, and they just don't like people that do that. Sad case, but you got to admire the man just stepping up and doing it and pleading guilty. He knew he was done. But we'll see how long that lasts. Maybe he'll play games and try to withdraw his guilty plea.